The House will now have under consideration House Bill number 101. Good gentleman from District 22.
Thank you, Mr. Speaker. I ask unanimous consent to dispense with further reading of House Bill 101.
You've heard the unanimous consent request. Is there an objection? Hearing none, the gentleman is recognized to begin the debate.
Thank you, Mr. Speaker, and good ladies and gentlemen. Before you, I have House Bill 101, which gives flexibility for legal counsel to the members of the different agencies within the government. Currently, they are assigned legal counsel by the Attorney General. And I believe that this flexibility should be available to all the agencies, because we all know and we have seen in this time that there's difference of legal opinions. If there's difference of legal opinions in this body, and the danger of having one opinion, I can share with you that if all of you had to agree with my opinion, this place would be a disaster. And so we don't want to declare a national disaster or anything here either. But I do believe all the agencies should have an opportunity to select their own legal counsel. We've seen different opinions nationally, where if you disagree with somebody's opinion, you get ridiculed, or you get into the woke movement where you're not allowed to say anything anymore if you disagree with them. We need the diversity of opinions in the legal sector, and we need difference of legal opinions if the agencies so desire. So this bill does not tell them they have to. This bill tells them that they can. They will have that flexibility to select their own legal counsel. And I've had some experience with that here. I drafted a bill several years ago where the Attorney General gave me an opinion that this bill was unconstitutional. So I went to a former Attorney General and got an opinion that it was perfectly constitutional. Who's right? Who's in the chair? Who has the right to decide? So we can have those discussions of whether one is constitutional or one is not, but we should be able to allow those opinions to be brought forward. I've sat on a couple of years, last year, the year before, I can't remember, with negotiation on a water issue here in Treasure Valley. We had legal counsel there, and we had the DAGs from the Department of Water Resources. There was disagreement on how we could move forward. We finally worked it out after, I think, about 6 weeks, meeting twice a week, and it got to be interesting once in a while where some of the attorneys would be just flat out mad at the other one and stuff like that. But there were diverse opinions. Diverse opinions are good to have. They're good to have in this body. They're good to have in our agencies. And so, ladies and gentlemen, also there's some question on the fiscal note. I don't know how many agencies may want to hire outside counsel. I'm going to assume, and I made an assumption in my fiscal note, that 90% of the agencies are happy with the AG, and maybe 10% of them would be interested in outside counsel. Is that the right number? I don't know. Maybe there's more, maybe there's less, maybe there's nobody. But I believe that each agency head should have the flexibility to select their own legal counsel to put forth their positions that they would want. We would want, you know, when we hire a legal counsel, I want the guy who's going to present my point of view and my perspective on the issue. And so with that, Mr. Speaker and good ladies and gentlemen, I'll turn my time over to the good representative from District 12.
Will the gentleman yield?
Yes, the gentleman yields.
The gentleman has the floor to finish the opening debate.
Thank you, Mr. Speaker. This bill does contain some technical corrections, of course, but the meat of the bill is simply allowing agencies a choice of private counsel should they so choose. Our good Attorney General represents a multitude of state boards, agencies, the legislature, the governor's office, and various entities. Representing all of these agencies and entities sometimes puts his clients at a disadvantage, however. In appellate arguments, in litigation, and negotiations, I've seen it. It simply is not possible for one office of 127 attorneys for an entire state to represent competing interests. For example, the Defending Women's Sports Bill, which many of you voted for, is now in appellate courts. And then that same Attorney General's office, the good Attorney General, must also represent the diversity agenda of BSU. They don't. How can you possibly in one office represent both sides? That comes up in many instances, and many of you have had cases of examples you've shared with me of that where you're a little bit uncomfortable. How could this be? I got an opinion one way, now I have the good Attorney General arguing the other side for me, but the court is aware of that first opinion. And there are times when we need to allow our agencies to make a choice to hire outside counsel. Upon passage of this bill, I anticipate most agencies will stay with the good Attorney General in his office for legal services. However, there will be times when it is in the best interest of the state of Idaho to hire outside attorneys. As in modern medicine, where physicians specialize, so have lawyers specialized in water law, constitutional First Amendment law, eminent domain. It is these specialist attorneys that will be hired for some cases for the state, and should be. No agency aside from the good Attorney General's office has come to me with an objection to this bill. It's been out there quite a while. I held it up for a while so we could get more comments. Didn't get much. No lobbyist or organization has expressed to me any objection to this bill. I've had no direct communication from the good Attorney General himself until this 15-page memorandum appeared on our desk just moments ago. I have not had time to read that. And then there is one question somebody did ask me on page 3 of the bill. Why are we getting rid of the common law authority for our good Attorney General with this bill, Mr. Skog? Because by definition, common law powers are not codified, and to generically codify all common law powers is to codify an unknown set of powers. And also, any common law powers held by the AG are subjective to legislative change. Thus, codifying all common law powers would be contradictory to subsequent legislative changes in those powers. In short, if the AG has common law powers, he doesn't need a statute saying so, especially when the reach of those powers is unknown, such as the legislature can't tell whether they should be legislatively changed or not. The real question is, why was that paragraph ever put in there in the first place?
Good gentlemen, when you read from other sources and stuff, you do that with the permission of the body. No one objected, so it must be okay with them, but if in the future you probably should ask.
My apologies, Mr. Speaker. The pendulum has swung a bit on this historically. You may or may not be aware that back before the 1990s, there were about 86 deputy attorney generals, and there were a lot of private attorneys. Too many private attorneys were being hired by the state agencies. So this was reeled in by past attorney generals. Well, now the pendulum has swung too far the other way, where we can't get private specialty legal counsel when we need it. So this bill just gives us the opportunity to bring that pendulum back to the middle, and that's my goal in supporting this bill. I do ask for your green light.
Thank you. Is there further debate? Good lady from District 18.
Thank you, Mr. Speaker. To debate against the bill?
Have the floor.
Thank you. Well, let's see. Where do we? You all have the Attorney General opinion that's in front of you, and I'll leave that to you to read on your own. I'm really more going to address the policy perspectives here, although I think it is important for you all to know that at least it is the Attorney General's opinion that this bill is unconstitutional and would likely be struck down. But putting that aside, I really think there's a very compelling policy point to look at here. This is ostensibly a blank check to the agencies, and it can get really expensive. There's a lot of speculation going into that fiscal note, and if I were a betting woman, which I am, I would say that it's going to be a whole lot higher than what that fiscal note indicates. The hourly rate for an attorney general that's at an agency is $57.88 an hour. And these are highly qualified attorneys who specialize in that area, who are spending their full-time job in that agency's work. That is the bargain of the century. I understand it's also $88 if they're contracted to an agency. So if they're not fully placed at that agency, then it's $88 an hour. My understanding is the amount that this body has paid when it's contracted with Holland and Hart, a local law firm, is about $470 an hour. My rate is $725 an hour, if any of you would like to use me for this kind of work. But all I can say is the taxpayers of Idaho are getting a heck of a deal, getting an expert, highly qualified attorney at $57.88 an hour. And if we want to go down the path of writing a blank check to agencies saying they can hire as much as they want from people at 8 times that rate, then this can get very, very expensive. But not only is there the cost of the actual legal fees from hiring these vastly more expensive outside attorneys, but I think there's going to be a pretty substantial increase in other legal fees in terms of litigation, downstream lost court cases. Because if you think about it, you know, the reason they're probably going to an outside counsel is because they didn't like the opinion they got from the inside counsel. They're shopping around. They're looking for a hired gun attorney who's going to tell them what they want to hear. In fact, the good gentleman from 22 in his opening statement said, when I'm looking for legal services, I want someone who's going to go with my viewpoint.
Speaker, I object. Well, she was so wound up that I forgot what I objected for. She was impugning the motives of the sponsor of the bill. She's impugning the motives of the sponsor of the bill.
Mr. Speaker, if I might respond, I was suggesting nothing about the motives of the sponsor of the bill. I was quoting his opening statement. Thank you. I was alluding to the agencies that would be seeking outside counsel, nothing having to do with the sponsor of the bill. But if these agencies don't like the answer they got, then they're going to go look around for a vastly more expensive counsel who will tell them what they want to hear. The problem is when you're looking for legal counsel, it's really not the best idea to go find someone who just tells you what you want to hear. What you want is somebody who will tell you the actual lay of the land, what the law actually is, what the case law actually says, what will actually likely happen if you get in front of a court. It's best not to sugarcoat it. After 20 years in this profession, I can tell you, you do not want to sugarcoat this. You want to get real legal advice. You really don't want somebody who's going to tell you something that is not, in fact, what the law is and is just telling you what you want to hear. That can get really expensive really fast. And we've seen that happen. We've seen that happen in Idaho. There was a case with the Idaho Department of Transportation a number of years ago where they bypassed the Attorney General, got an outside counsel who told them, well, maybe something closer to what they wanted to hear, and they lost the case and lost the state $1.5 million as a result. So I think the costs are going to be much, much higher if we go down the road of not getting necessarily the best legal advice or the legal advice that is in line with the state. So to be clear, the Attorney General owes a fiduciary duty to the state of Idaho, not to that agency. And so they are obligated to give advice that is in keeping with the best interests of the state of Idaho and of the people of the state of Idaho. That would not necessarily be the case for counsel that's retained by an agency. They would represent only the agency and only have to do what they believe is in the agency's best interest, which may not align with what is in the interest of the people of Idaho and of the state of Idaho. So I think we're creating conflict of interest problems, dramatically increased costs for the people of Idaho, potentially bad policy. I think we also lose some element of transparency when we're going with counsel who is not an elected constitutional officer and not accountable to the people of Idaho in the same sense. So I think this opens a very dangerous door for many reasons, and I think the fiscal note is, as I said, vastly, vastly higher than what is indicated, and for a number of reasons, I really would urge you to give this your red light.
Thank you. Is there further debate? Good lady from 23.
Thank you, Mr. Speaker. To debate in favor of the bill.
Go ahead.
First of all, I wanted to address a couple of comments that were just made after going through a committee hearing discussing costs of attorney generals. It's been stated that they charge $57.88 an hour and $80 contracted, but I want you to know if you look at what they actually contract services out, it's actually more along the lines of $250. So it's a little bit misrepresenting the actual cost of the Attorney General to say that it's just $57 or $80 as contracted to an internal agency. Secondly, I'd like to remind you all that embedded in the $57.85 and the $80 are taxpayer dollars that pay the AG's overhead. So it's a little different if you're an outside attorney contracting with someone. You have to pay your own overhead, which accounts for those increased costs. Also, I would like to point out that the beautiful thing about the Idaho State Legislature is we appropriate the money. We appropriate the money. That means that no agency can run out there and have this ad nauseum legal bill and expect it to be covered by the Idaho State Legislature, because we give them a budget and they can choose to live with it or not, and then we work through our good folks at JFAC to bring a supplemental, and we decide whether we want to fund that supplemental or not. That's how that works. It's not a runaway checkbook. It's not an unlimited fund set that they get if they choose to have an outside attorney. I would also point out, for those of you who have perused the short novel that was dropped off at our desks, that apparently we did just fine before the early 90s when we consolidated and they were using other attorneys, and it was not unconstitutional. It happened to work out. So we have the tools to control costs. There's not a constitutionality in the past. I don't know what changed. That's not addressed that I could find in my paperwork. But I think those are two issues that have come to light, and we really need to be serious about that, and those are not problems with the bill. And I would urge a green light.
Is there further debate? Gentleman from 19.
Thank you, Mr. Speaker. To debate against the bill. I've heard over the last couple of weeks of deliberation the needs for this bill. I've heard that our agencies need flexibility, that they are occasionally hamstrung by the inflexibility. I've heard that there are instances of litigation where the Deputy Attorney General just doesn't provide the level of specialization that the agency needs. I've heard that sometimes you don't want contrary advice from your lawyer. I get that. Sometimes you just want a hired gun. Now, chalk this up to freshman naivete, but I get the feeling that a good conversation with the other gentleman on the second floor might get us to a more desirable outcome than this bill. In fact, I think that would be preferable, because this bill has two major problems. We just heard from my colleague from District 18 about the cost issue, but I think that that's the good news. I think there's a bigger problem. Certainly as a taxpayer, there's a bigger problem. We are considering removing the language from page 6, lines 1 through 10. And if we do that, the Attorney General would no longer recommend to the State Board of Examiners which attorneys should be authorized to provide legal services for the state. Those 8 or 9 or 10 lines provide an important tool for ensuring that our private attorneys who represent the state are at least ethically qualified and cost-effective. So in short, Mr. Speaker, I have 3 nagging questions. How much is this going to cost? How are we going to ensure that only qualified attorneys are serving the state and the taxpayer? And 3, wouldn't a good conversation with the other gentleman on the second floor be a more desirable outcome? I'll be voting no.
Is there further debate? Hearing none? Will the good lady, or good, anyway, I know it's the good gentleman from District 22, but it looked like another person was going to stand up in front of you. So anyway, gentleman from 22, you have the floor to close the debate.
Thank you, Mr. Speaker, and good ladies and gentlemen. Thank you for the debate. Just to clear up one thing that the good lady from 23 also mentioned, all money spent by agencies has to be appropriated by the legislature. All line items, individual counsel, they'll have to put into their budget what they want. If they want independent counsel, it'll have to be approved by JFAC, and then it'll have to be approved by the legislature. We've seen some bills come through here that don't always get approved. So the fiscal responsibility will still be within the legislature. And good ladies and gentlemen, I think this is a good step forward, and I would urge your green light.
Gentleman from 12 yields.
You may have the remainder to close.
Thank you, Mr. Speaker, colleagues. I'm told I should declare a Rule 80, though I've never worked for the government since I was a prosecutor and don't intend to, so I'm declaring a Rule 80.
All right, your declaration under Rule 80 of a possible conflict will be noted in the journal.
The conflicts that many of you in this room have experienced over the years is real. You know what those are. You've told me those stories. Attorney shopping, by the way, is okay. When you're shopping for an attorney, you're shopping to win. I'll tell you a story. A fella called me from Montana at my office. He knew I was an attorney. I don't remember meeting him. He said, Bruce, I'm in trouble. I've been charged with a serious crime, and I need the cheapest attorney I can get in Montana. I don't have a good budget. I said, hey, buddy, what's the price of losing this? You're going to prison for a long time. I said, you get the most expensive attorney you can in Montana. So he hung up the phone, and I didn't hear from him for 2 years, and he called me from another state. He said, Bruce, I just want to say thank you for that advice. I hired the most expensive attorney. I won my case. I'm a free man. Just thank you for that. So it kind of applies here. This bill does not give an open checkbook. Page 5, Section 6 of the bill takes care of that. Again, how expensive is it to lose a case? What value is it to win a case? Anyway, I thank you for your time. I thank all for the debate. There's been some good questions. I ask you for your green light respectfully.
Thank you, good gentlemen. The debate is closed. The question before us is, shall House Bill number 101 pass the House? The clerk will unlock the machine and the members will record their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the vote, read the pairs.
Gibbs votes nay. Bundy votes aye. Wood votes nay. Holtzclaw votes aye. Ehart votes aye. Chu votes nay.
The vote count shows 54 in favor with 15 against and 1 absent. House Bill number 101 has passed the House and will be transmitted to the Senate.